matter is taken up together. The captioned writ petition has been filed seeking issuance of a writ of mandamus, directing the respondents to consider the petitioners under the old pension scheme, along with the benefits ensuing from it, and also sought for a direction against under the new and to refund money collected so far under the grab of new pension scheme. Full stop. Next paragraph. Factual matter. The petitioners were appointed as a veterinary doctors by the Karnataka Public Service Commission (KPSC) complete under the Karnataka Civil Services direct recruitment by selection rules 1973, and were discharging their duties in various parts of Karnataka, and the appointment of the petitioners were on various dates prior to 1/4/2006. And the terms of appointment including but not limited to pay, promotion, pension, etc. are regulated by the Karnataka Civil Services Regulation of Promotion, Pay and Pension Act 1973 and Part 4 of the Karnataka Civil Services Rules. First respondent on 31/3/2006 introduced the new defined contribution pension scheme inverted comma NPS intent as per Annexure B with effect from 1/4/2006. Full stop. The NPS as per the said notification was mandatory to all the new recruits to the state government service joining on or after 2006, and the monthly contribution shall be 10% of the basic pay and dearness allowance thereon, to be paid by the employee and matched by the state government in equal proportions. The first respondent filed office memorandum dated 12/7/2007 at Annexure W clarified that the persons who were already in regular government service prior to 1/4/2006, can apply for post in the same or other departments under the state government service through proper channel, and on selection they are relieved by the competent authority or tender technical resignation under 252B of the 50SR rules, and subsequently the new post on or after 1/6/2006, will not be treated as a new recruits and therefore will not be governed by the NPS and shall be governed by under the KCCR at Annexure W. When the facts stood thus, in pursuance of the notification dated 19/4/2011 issued by the Karnataka Veterinary, Animal and Fishery Sciences University at Annexure B, the petitioners were relieved from their duty as veterinary doctors upon their technical resignation and were appointed as the assistant professors in Veterinary College, Shimoga, Hassan, Bangalore and Bidar since 2012. Next paragraph. While the petitioners were serving as the veterinary doctors, the benefits under the old pension scheme was applicable. However, Upon tendering their technical resignation and being appointed as the assistant professor, the petitioners have been denied the benefit of the pension scheme on the ground that their services cannot be considered as continued service, and the services rendered by them in an university is not eligible for an old pension scheme under Rule 224A of the KCCR, while Annexure X, Y1 and the petitioner are aggrieved by the approach of the respondents, aggrieved by the approach of the respondents, and in not considering the petitioners under the benefit of old pension scheme. Full stop. Next part. Heard the learned senior counsel for the petitioner or his learned senior counsel for the and the learned or his for the respondent state Anita, learned SCGP for respondent number 1 and 2. Your name? Sorry, for respondent number 3. Yes. ಆಮೇಲೆ ಎಲ್ಲಾರ್ದು ಹೆಸರು ಹಾಕೊಳ್ಳಿ. He is Venkatesh. Who is Venkatesh?
Your Lordship, I
988.
Venkatesh for the petitioners in WP ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. And this is the contention of the learned senior counsel that statute number 13(2), chapter 3 of the Karnataka Veterinary Animal and Fisheries Services University statute regulates the salary and conditions of the service of the petitioner, and the statute 36 subclause 4 subclause 1 of the chapter number 6 of the Karnataka State Veterinary Animal and Fishery Services University statute retrieve the same as the statute number 13(2) of the chapter 3. The senior counsel would also would contend that the petitioners are entitled under the old pension scheme under Part 4 of the Karnataka Civil Services Rules by virtue of 252B. 252B. The only permission and sanction of the respondent, the petitioner made an application to the university on 4/6/2007 and thereafter was appointed through a proper selection process, and there was no break in the service rendered by the petitioner while serving as a veterinary doctor, and that of an assistant professor. The resignation tendered by the petitioner is a technical resignation, inverted comma, in terms of Rule 252B of the Karnataka Civil Services Rules, and the petitioners are entitled to continue under the old pension scheme as being applicable to the employees prior to 1/4/2006, as is evident from Annexure W as per the government order. Government Office Memorandum dated 12 July 2007. Learned counsel in support of his contentions has relied upon the judgment of the division bench of this court in WP 10019 of 2021 in the case of Raghu S versus State of Karnataka, dated 26 May 2022, and the judgment of the coordinate bench of this court WP 104477 of 2015 dated 8 March 2021 in the case of Dr. Gundappa, son of Channappa Kalburgi. That is this, and then 2020 Part 1 KCCR 263 in the case of Sri Chandrasekhar G versus State of Karnataka and others. Per contra, judgment. The learned senior counsel would also contend that the modalities clarified by the Ministry of Personal Public Grievances and Pension Department of Pension and Pensioner Welfare with respect to the implementation of NPS with respect to central government employees who were availing benefit of OPS, whose position on mobility changed from department to department, they are entitled to be continued under the old pension scheme. And on consideration of the aforesaid clarification, several states, including the state of Karnataka and various departments in Karnataka, have considered the employees under the old pension scheme and the modalities are being adopted by the departments and department. Senior counsel would also contend that the that at annexure that by that the government order W date dated 12th July 2007 has clearly clarified about the applicability of the old pension scheme to the persons who are already in regular government service prior to 1st April 2002. Stating this ground, learned senior counsel that to allow the petition. Per contra, learned counsel appearing for in which you have filed your objections. Next, learned counsel for the petitioner in the connected petition. You appear only in 1449. So the learned senior counsel has argued for the petitioners in WP 1113 and 1439. And who appears for the students? Yes. And Aksana, you have to say that. And Mr. Venkatesh.
I appear for first petitioner in 1439. First petitioner in 1439.
Then that only. Yes, you have some addition of arguments?
No, Your Lordship, I was there yesterday, Your Lordship. See what he was, I adopt his arguments, Your Lordship.
For the petitioner in WPP so and so adopt the arguments addressed by the learned counsel. So and so. Yes. For contra, yes, Mr. Counsel, whom do you appear for? In which petition? Just say respondent university. You appear for the and who appears for the university in other petition?
9088. I am appearing for the third respondent. Raichur University.
For contra, the learned counsel appearing for the university, our and KG9 would submit that.
R2, my lord. R2 appointment order.
University alva ನೀವು?
ಹೌದು.
Okay. Where is your objection, Mr. Counsel?
I filed, my lord. Annexure R1 and R2. R2 is the appointment order, madam. It is very clear. Para 2 is very clear, madam. Not applicable is accepted.
Correct.
Page is 15, my lord. Ink page 15.
Yes. Learned counsel for the respondent number 3. Per contra, the learned counsel appearing for the university would contend that the petitioners were government employees recruited by learned counsel for the respondent in addition to the various other contentions raised in their statement of objections would contend that the petitioners were government employees recruited by the KPSC under the Karnataka State Civil Services Rule and were therefore bound by the said rules and on their own accord opted out of the government service, applied for appointment in the respondent university by recruitment 11 to be considered for various teaching posts. And the petitioner having been relieved from the government service and entered the university voluntarily in the year 2010, when after coming into force of the new pension after the long 10 years, seek a remedy that the old pension scheme is applicable to the petitioners. Full stop. Learned counsel would contend that the office memorandum dated 12/7/2007 clearly clarified that the persons who are already in regular service, government service prior to 1/4/2006 can apply for post in the same or other department and department. It's better. You're supporting this. In your para number 6, you are supporting the contention. Correct. So according to you, 1/4/2000. This is what you said in para number 6. Then, Learned counsel
Can apply.
Just learned counsel, learned counsel would contend that the government, by its order dated 5/3/2011, has delegated the power to the secretary of various departments of the state government for approval of proposals under Rule 424A of the Karnataka Civil Services Rules, and the proposal regarding considering the previous service rendered by the government employee in other government departments on certain terms and conditions are laid out, and it is for the petitioners to make appropriate representation to the government seeking consideration of their case, and would contend that the petition is against and the allegations made against the petitioners are not sustainable. Full stop. Mehmed SCGP, have you filed your objections? What is your condition? The CGP would contend that the petitioners cannot be adapted in the old pension scheme. Would contend that pursuant to the clarification, pursuant to the letter issued by the university recommendation, pursuant to the letter issued by the letter forwarded by the university to recommend that the petitioner under the old pension scheme was forwarded to the state, and the state in pursuant to this has sought for certain clarification, and the matter is pending consideration. Now, and learned SCGP would contend that the petitioners could make necessary representation before the appropriate authority, and representation to the necessary appropriate authority, and the appropriate authority has to consider their said representation, and not at this stage of filing this petition. Please. Next. Aita. This court has considered the rival contentions urged by the learned counsel for the parties and perused the entire material on record. relevant provisions that needs to be considered, the relevant rules that needs to be considered is statute number 13(2) of chapter 3 of the Karnataka Veterinary Animals and Fisheries Sciences University statute which reads as our 13(2). Second is 36(4)(1) of 36 subclause 4 1 of chapter 6, then 252B of the Karnataka Civil Services Rules, 224A, we just write it as this. We'll see. Statute number 13(2) of chapter 3 reads as under. Extract. Statute 36(4) subclause 1 of chapter 6, 7 of the statute reads as under. Get it here. And then the 252B of the Karnataka KCSR rules reads as under. The Government of Karnataka, by its office memorandum dated 12th July 2007, on after the introduction of new pension system called as new defined contributory pension scheme inverted comma, which came into operation with effect from 1st April 2006, and since several department and other implementing agency had sought for clarification as to whether the government employees who were already in service prior to 1st April 2006, if appointment in different post under the state government and join the new post on or after 1st April 2006 will be governed by the said new defined contributory pension scheme or the pension benefits under the Karnataka Civil Services Rule. The government clarified that if persons who were already in regular government service prior to 1st April 2006, apply for post in the same or other departments under the state government service through proper channel, and on selection they are relieved by the competent authority or tendered technical resignation under section 252B of the Karnataka Civil Services Rules and subsequently join the new post on or after 1st April 2006 will not be treated underline as a new recruit, and consequently such person will not be governed by the new defined contributory pension scheme, and they will be continued by the pension scheme under the Karnataka Civil Services Rules. The statute, next paragraph, the statute 36(4)(1) is in respect of the employees of university who have earlier rendered service in any department of the government of Karnataka, government of India or ICAR or central universities in India, and in case of absorption, pensionary benefits shall be admissible subject to the guidelines, if any, from time to time. In light of this, the office memorandum dated 12th July 2007 issued was squarely applicable to the petitioners herein. It is also relevant to note that next para, that the ministry had the Ministry of Personal Public Grievances and Pension Department of Pension and Pensioners Welfare had clarified certain modalities with respect to the implementation of National Pension Scheme. National Pension Scheme in with respect to the central government employees who were availing the benefits of the old pension scheme, whose position on mobility changed from department to department and they were entitled to be continued under the OPS. The same was adopted by the state of Karnataka and various department and the respondent number one by the office memorandum dated 12/7/2007 having been clarified about the applicability to the persons who were in regular government service prior to 1/4/2006. The pursuant letter. Is it all letters? What are those? X Y1 and Y2. The internal communications. Subsequent communications that the services of the petitioners cannot be considered as continued service as the services rendered by them is in a university and is not eligible under the old pension scheme is contrary to the office memorandum at W dated 12/7/2017. The right which has been accrued to the petitioners cannot be taken away by an administrative instructions as it is proposed by the respondent by the communication on which the respondents have placed reliance in their statement of objections. Stop. The right of pension cannot be taken away by a mere executive or an administrative instructions and held to be a right to property under Article 31, subclause 1 of the Constitution. Pension is not a bounty. It is a benefit accrued in the nature of property and cannot be taken away by anyone at anyone's discretion and without the due process of law as per Article 300A of the Constitution. The Apex Court has clearly laid down in the case of Dr. Hiralal versus State of Bihar and others uh, reported in 2020 Part 4 SSC 346 at para number 22 to 24, which reads as under. The Apex Court in another judgment reported in 2013, Part 12 SSC 210 in the state of Jharkhand and others versus Jitendra Kumar, Srivatkala and others has laid down the said proposition, which reads as under 14 to 16. The petitioner has joined the government service prior to 1/4/2006 and 1/4/2006 and by way of a technical resignation under section 252B of the KCCR as which is the criteria as enunciated in the office memorandum dated 12th July 2007 for the persons to be eligible for old pension scheme, and the technical resignation having been appointed, having been accepted, now the respondent cannot contend that contend that since the petitioners have voluntarily opted out of the government service and entered into the university, the new pension scheme is applicable to the petitioners. The next, it is relevant to note that the petitioner had submitted representations on 4/6/2007 to the university stating about uh, uh, to the university, which was considered in the proceedings of the meeting held by the Board of Management on 27 August 2007. And at item number 6, it has held that extending the pensionary benefits to new recruitees, and the resolution was passed that the proposal was accepted and accorded its approval to approach the government for an order towards the payment of pro rata pension contribution for the recruits either from their parent department or concerned employee to count their previous service of payment of pensionary benefit by the university. The same having been forwarded to the government on 25/8/2020. 25/8/2020. The government has sought for certain clarification in this regard. Be that as it may, the petitioner having been appointed prior to 1/4/2006, the contention of the respondent that the new pension scheme is applicable to the petitioner is not sustained. The 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 contention of the respondents that the previous service becomes countable only when it is rendered in other department of the government cannot be sustained as the petitioner had submitted the terminal resignation as contemplated under section 254 252b, and the absolving of the petitioner in the university is to be treated as the petitioner was working in the other department of the state government. Therefore, the contention of the respondent that the petitioners are not the government employee and is not sustainable. Full stop. The coordinate bench, the division bench of this court in learned, so both the learned counsel appearing for the respondent would contend that the petitioners would submit their representation in this regard, and the same would be considered by the respondent accordance with now. This contention would be a futile. This exercise by this court would be a futile exercise, as their eligibility and entitlement uh, is not in dispute, as they are appointed in government service from 1/4 prior to 1/4 2006. 1/4 2006, and the entitlement of benefit to the petitioner is evident from the material placed before this court. Accordingly, a necessary direction needs to be issued in this regard. The coordinate bench of this court in the case of Raghu S. stated Supra as held that was under circumstances where the regulations was under the circumstances where the regulation was assailed, and the retirement benefit was be uh, sought to be implemented under the old pension scheme, and the division bench of this court directed the board to give an option to the petitioners with regard to their retirement benefits under the old scheme. Old scheme. The coordinate bench of this court in the similar circumstances as well that that an appropriate mandamus has to be issued to the second respondent to reckon the petitioner's previous service rendered for the purpose of settlement of pension subject to the other conditions. Full stop. In the light of the circumstances made out, it would be appropriate total exercise, just remove that representation. Total exercise, just to let them consider your representation. So, in light of the reasons stated above, it would be appropriate if the representation or S slash yes representation, which is already submitted, or the petitioner is at liberty to submit a fresh representation to the respondents 1 to 3, and the respondents to consider the representation of the petitioners in accordance with the notification dated Office Memorandum dated 12th July 2007, the judgment of the coordinate bench of this court in 2020. The division bench of this court in Raghu's case, the coordinate bench of this court in Chandrasekhar's case, Kundappa, Justice Krishna Dixit. And pass appropriate orders strictly in accordance with law within a period of 2 months from the date of receipt of this order. It's there with you, and if all they want along with the petitioner is also at a liberty. The petitioner is also at liberty to submit additional documents along with the representation along with the representation, if not already submitted. So one is you will be giving the representation which is already pending, that would be considered, or the petitioner is at liberty to.
In our case, no representation.
Yeah, that is the event they want to file, let them give one more representation. That is in addition. No, what is that order request? The representation petitioner which has been submitted on in the year 2007 and forwarded to the 06/2007 and forwarded to the respondent government. Two representation. 6/2007, 27/2020. Representation. In addition, the petitioner is at liberty to file fresh representation along with the necessary documents to the respondent authorities. Respondent number 1 to 3, and the respondents 1 to 3 to consider the representation within a period of 3 months from the date, 2 months from the date of the filing of such representation, fresh representation, and the representation to be considered in light of the office memorandum dated 12th July 2007, Raghu, the judgment of the division bench in Raghu's case, the judgment of the coordinate bench in the case of Gundappa and Chandrasekhar, and pass appropriate orders strictly in accordance with law. You are not a necessary party. Now, what do you say about his presence in this? In view of the disposal of the writ petition, pending IS would not survive the consideration. So your representation to be given, and then that would be considered strictly in this light of this. Instead of going into all this, they can consider and pass. Thank you. This also will place on record, because that has, you say that it's been extended, so that limitation also should not come in their way. Look at it. Ministry passed certain orders that was adopted by you. You said that is applicable. Now, when you say this is also there, we will say only this. Yes. The learned council has placed learned council for the response. You have to add it where it is. Learned council for the respondent university has placed on record the office memorandum issued by the Government of India, Ministry of Personal, Public Grievances and Pension, Department of Pension and Pensionary Welfare, dated 11th June 2020. To contend that the cutoff date 28/10/2009 has been extended. So you don't want us to consider this applicability, so that their representation, whatever it is, there should not be any